Wait for Denise.
Looks like Denise is here.
Morning, David.
Good morning.
I checked outside this morning and they have not dropped off my cookies yet.
Oh, I'm sorry about that. It's just taking, it'll take another 6 months to arrive.
yeah, like July maybe, or August meeting.
No post office jokes, folks.
Because they're coming by boat.
Welcome, Denise. Can we check your microphone?
Okay, I'm better now. Sorry, guys. I mean, I've never had such a problem with logging in, but the internet is just messing up totally. So,
Well,
no apologies necessary.
Like I said yesterday, Denise, the issues you have are good case point out that why we need broadband on your side of the valley.
okay,
But,
let's make it happen.
Yeah, but there's a lot of kids out there that parents are trying to school them online, and I can imagine with your kind of problem, some people maybe just give up.
Yeah, we're dealing with that too.
Very good.
Good morning, everybody.
Good morning.
Good morning.
We're ready to go. Good morning, folks. Welcome to the second day of the 571st board meeting of the California Regional Water Quality Control Board, Central Valley Region. I am Carl Longley, chair of the Central Valley Water Board, and I'll introduce the other board members in just 1 minute. This is the second meeting we are conducting during the this is the fourth meeting we are conducting during the COVID-19 emergency. In order to comply with public gathering limitations and physical distancing requirements, and as authorized by the governor's executive orders, there is no physical meeting room. For people who only want to listen or watch the meeting, the board's customary webcast is available. In addition, we're receiving presentations and public comment through a Zoom meeting platform. If you intend to present or comment, or you think you might be interested in commenting, you should already be in the Zoom meeting room using the meeting ID provided on the board's website and the password you received from our staff. If you've not already received a password, you can email us now at, and this is all one word, agenda5, and that's AGENDA with the number 5 at waterboards.ca.gov. Include speaker comment, those 2 words, speaker comment in the subject line so that we can follow up with you. For those in the Zoom meeting, you will be on mute and your camera turned off until it is your turn to speak. Our meeting host, Gene Coughlin from our IT team, will then unmute you and ask you to turn on your camera if you have one. When you have finished speaking and the board members have completed asking questions, you will be placed on mute and your camera turned off. We appreciate your patience and understanding during this very extraordinary time. I also need to point out that we are going to be hearing item 20 before item 21 before item 20. Item 21 is the United States Army Corps of Engineers Western Placer County Habitat Conservation Plan slash Natural Communities Conservation Plan, Placer County. And item 20, which we'll hear last, is the Central Valley Water Board Enforcement Program update. I'll now introduce the other board members. Of course, we have with us today Carmen Ramirez of Atwater, our vice chair, Denise Cadera of Allensworth, Raji Bar of Bakersfield, Mike Bradford of Sacramento, and I'm Carl Longley of Fresno. I will now introduce the Executive Officer, Patrick Palupa, who will introduce his staff.
Good morning, Chair Longley, members of the board. Pleased to join you once again on the Zoom platform, though I very much can't wait for the day when we will all be meeting in person again. I'd like to introduce the 4 AEOs that we have. All of them are on the Zoom platform. 2 from the Rancho Cordova office, Adam Lapitz and JJ Baum. And then we have Clint Snyder, the Assistant Executive Officer in the Reading office, and Clay Rogers, Assistant Executive Officer in the Fresno office. We also have a number of staff from those offices online and a few from the Office of Chief Counsel. We have Senior Attorney Jessica Yar, and then Attorney David Lancaster and Attorney Bailey Toft Dupuis. And with that, I will turn it back to you.
Thank you very much. Mark, would you please lead us in the Pledge of Allegiance?
Sorry, Mark, you're
Sorry, I was
muted.
muted. My fault. Okay. I pledge allegiance
Pledge allegiance to the flag
to the
of the
United
United
States
States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. We'll move on next to agenda item 14, board member communications. Are there any further communications from board members?
No.
Hearing none, we'll move on to the public forum. Do we have any, Janelle, do we have any cards?
Well, we don't have any cards. It looks like we have a couple people who may be interested in speaking. I know associated with Terabella. If you are interested in speaking, please raise your hand and we will get to you in turn. And Jean, if you could let who's ever on the phone, if they're interested in speaking for the public forum, to what the star, I think it's star 6, is that correct?
Sure. Star 9 on
Star
a cell
9.
phone will raise and lower your hand. Star 6 will mute and unmute your phone for cell phones.
And remember the comment I provided earlier. If you've not already received a password, you can email us now at agenda5waterboards.ca.gov. With speaker comment, those 2 words in the subject line.
Showing that email address.
Good. That's better than me trying to say it.
All right, so it seems like we have Maria Thompson, Fred Beltran, and Dr. Will Green as 3 speakers, at least in the public forum today.
Good. Let's go ahead with the first speaker.
Bob, are you unmuting them?
And each speaker in the public forum will receive 3 minutes. They can request more time if they believe it necessary.
All right, I think first up we have Maria Thompson.
Hi, good morning. Can everyone hear me?
Hear you just fine.
Yes,
Great, thank you. Good morning, Chair and members of the board. Thank you for having me here to speak today. My name is Mariah Thompson. I am an attorney with the law firm California Rural Legal Assistance. I represent a community group of residents in Terabella called Terabella Voice for Change. You may be familiar with Terabella Voice for Change because we were designated parties in a August 2020 stipulated cease and desist hearing against Set and Pistachio of Terabella, where this board entered into a stipulated cease and desist order against Set and Pistachio regarding an ongoing nuisance odor that was being created by their pistachio processing facility in Terabella. I am before you again today to again address this issue. Set and Pistachio has continued to maintain a very severe ongoing odor nuisance in the community of Terabella, despite the fact that they are currently subject to a cease and desist order. They actually were just issued a notice of violation for violation of the cease and desist order on Wednesday of this week. And we are here today, both myself and other members of Terabella, to request that the board take immediate action and progressive disciplinary action against Set and Pistachio, because they have continually demonstrated that they are both unwilling and unable to comply with their water permits, as well as with the law in regards to these nuisance conditions that they're creating. We ask that you take these acts immediately, because they are almost at the end of their harvesting season this year. And that basically means that they've almost gotten through an entirely new harvesting season, making millions of dollars off the backs of residents who are no longer able to go outside or enjoy the outdoors because of odors and flies and things of that nature. And it's just unacceptable if they get to continue doing this while residents have to continue to suffer. We should also note that the same community group, Terabella Voice for Change, was recently forced to file litigation against Tulare County, with Seton being a real party in interest for their illegal construction of a massive expansion of their pistachio facility without any permits or authorities to construct, which the Tulare County retroactively approved using an unlawful CEQA act a number of months ago. So just to sort of point out that these bad faith moves continue happening on behalf of Set and Pistachio to just continue to thwart the law in order to operate this facility, even though they're unable to do it in compliance. So we do ask you to take action today, and I thank you very much for your time.
Thank you. Any questions from board members?
Yes. Yes. I'd like to ask Patrick, the expansion of the facility there without permits and the odors continuing, can you give some more information on that?
I wouldn't go into it in too great a detail, I think, because if this matter does come before the regional board, we don't want to prejudice the future action and potentially jeopardize an enforcement action should one come before the board. I will say that the board's prosecution team in the Fresno office is looking into those issues. For our purposes, very often the land use authority and the permission to build authority happens at the county level. But once you start using it for discharging waste, that's when you absolutely need a permit from us first. So it's a separate but related action with respect to, generally speaking, when you can start operating those type of facilities. Some folks get it before they start operating. Some folks get it, before they start building. Others folks get it after they start building. For our agency's purposes, it's when you start putting waste into it, when you start using it for waste discharge. That's when you need a permit for us. So again, I think we're tracking that litigation. Office Chief Counsel is tracking that litigation, and Ms. Thompson, just for your benefit, both your letter and the notice of violation were provided to all the board members for their review prior to this board meeting. So they are aware of the issues that you've raised and are aware of the substance of the notice of violation. Again, I wouldn't get into too much discussion here, simply because if we've got a pending enforcement action, if something starts gearing up, we don't want to have any of the board members potentially prejudice themselves and take them out of consideration for sitting and adjudicating a matter that might come to the board in the future.
Thank you, Patrick.
Any further questions or comments from board members?
Just as a point of clarification, I think it was mentioned that there was an authority to construct. That authority is a permit provided by the San Joaquin Valley Air Pollution Control District, and not necessarily just the county.
Gotcha. I appreciate that.
Any further questions?
Attorneys are tracking that one.
Hearing none. Thank you very much for your comments. We'll go to the next speaker, please.
Fred Beltran.
We don't see a Mr. Beltran in our participants.
He appears to be sharing the screen with Ms. Cipre's webcam. So look for Lupe Cipre.
Yes, she's sitting here next to me. So I'll speak and then I'll let her go after me. Thank you, board, for allowing us to speak. As Mariah explained what's going on, my concern is the fact that, the board is set up for a whole purpose.
Mr. Beltran, if you could, for the record, can you let us know who you are, where you're from?
Okay, I'm sorry. Yeah, Fred Beltran, 24737 Terabella, California.
Appreciate it.
And you're representing yourself, is that correct? Or
I'm representing the group Terabella Voice for Change.
okay, very good. Go ahead, please. And you have 3 minutes.
And, okay, thank you. And so, us living here, we see, we're seeing the issues here on a daily basis. We're going on 3-4 years, and actually was happening prior to this, the smell. The comments that the CEO of Seton has made regarding how they're going to fix it is, kind of up in the air. But my main concern is to make sure that the board realizes, the entire board realizes what their responsibilities are. You're there to protect the public. We're a small fish in a big pond. Seton's got millions of dollars. We have a community here that's low income. We're hoping that you will help us. You will help protect the residents here, and part of that protection would be some kind of progressive enforcement, because I think that's the only way that some of these big companies understand. I know that they're going almost to the end of the season. They're going to be making millions of dollars, and here we are still suffering. So I appreciate your time. Thank you very much.
Any questions for Mr. Beltran?
I have no question, but I appreciate that he, takes the time to reach out to us.
Thank you. Any further comments by board members? We have another speaker, I believe, has 3 minutes.
Morning. Good morning. Can everybody hear me?
We can hear you.
Great, thank you. My name is Lupi Cifres. I am a resident of Terabella. I'm speaking today on my behalf and representing my family directly. I want to thank the board first for giving me the opportunity to speak to everyone. I do appreciate and value your time. I just wanted to touch bases in regards to the issue that we have in front of us about Sutton Pistachio. I live downwind from the actual pond, so 99% of the time, anytime any odor is released from any type of water releasing from their waste charge, I get the smell. We get the odor, I should say. It is very strong. I'm a mother of 3 children. I have an elderly mother that lives with me, and we like to barbecue. We like to have family gatherings. We're a large family. Unfortunately, we did have my daughter's 18th birthday. We did have a small barbecue with my direct family. We had to move it immediately inside because of the smell was so horrible. It was like we had maybe, dead animal in our backyard or on the barbecue. I mean, you literally can smell the disgusting smell of it, and it was very stomach turning. Words are very hard to describe what the smell is like. But I asked the water board to please, step in and assist our town. I can have a lineup of residents coming in and speaking with you that the issue has not gotten better. On the contrary, when the smell is here, it is so horrifying that you're not able to enjoy any outdoor activity. We've canceled a few of the drive-through events that we had planned for one of our local churches because of the smell. I mean, we can't guarantee we'll begin, but yet during the activity, the smell will come in, and so we have to cancel everything. So I asked the board to please take hands into it, please take initiative, and please, help us in regards to the smell. We understand Sutton is a large corporation and a big company. I mean, but please, I know that your office is there for a reason, and I have faith that you will be assisting us in this issue. So as a community and as my family, we ask you to please assist us in this problem.
Thank you for your testimony. Are there any questions for Ms. Cifres?
Thank you for coming and describing the odor in detail. It sounds pretty horrendous. So thank you.
I also would like to say I appreciate your testimony and your description of what you all are dealing with. I could get a visual of it. So thank you for sharing.
And thank you very much again. We'll now take testimony from Dr. Will Green.
Dr. Green, you're unmuted. You are on your cell phone, *6, mutes and unmutes. And we do not hear you, Dr. Green. I'm actually sorry to say I don't see Dr. Green on the list any longer. I think he may have had a dropped connection.
We can come back to Dr. Green later if you can get him back on. As has been stated previously, the board staff are now addressing this particular issue, and we will be provided updates as appropriate in the future. And thank you all for your taking the time to come and speak in front of us today. We'll move next to the executive officer's report, and in the meantime, if you can get Dr. Will Green, we can take him down the road this morning. On agenda item 16, executive officer's report, are there any further discussions? Patrick, you put a good report together.
It looks like we have another phone call on the line.
Looks like Dr. Green has rejoined.
You have Dr. Green.
Yes.
Very good. So
Dr. Green, I'll ask you to unmute.
Let's go back to public session, and we'll hear Dr. Green.
Morning.
Good morning.
Good morning.
We hear you.
Hello. Good morning.
Good morning, sir. You're testifying now to the Central Valley Regional Water Control Board. Please state your name and your address. And
thank you. This is
who you represent. And my name's Carl Long. I'm chair of the board. Go ahead.
Yes, Dr. Langer. This is Dr. Will Green. We met virtually in August. I want to speak with you, the members of the board and the staff. We spoke on August the 14th in Sacramento, and behalf of myself and the participants who spoke at that time about Sacramento's combined sewer system, we want to thank you for listening to our concerns and for taking them seriously. Letting you know that we plan to continue to advocate for the permanent solution to this critical issue that we raised. And we want you to know that we're grateful for you continuing to hold the city of Sacramento accountable. And thank you for this opportunity to express our gratitude.
Thank you for your testimony. You stated you thanking us for holding the city of Sacramento accountable.
Yes.
Did you misspeak, or could you explain that further?
Oh, this was in regard to our meeting from August the 14th, of where the plan was to have a follow-up workshop to further investigate the efficacy if and when we see more of the superstorms with climate change.
Very good.
The concern about the water sewer vault in McKinley Park and its ability to solve the problem as promised.
I'm on board. I'm sure the other members are on board much sooner than I was. Thank you, sir.
Thank you very much.
Any board members with comments at this point?
Dr. Longley, I'd just like to comment. It's good when you have the residents, they voice their complaints, but then come back and acknowledge that they saw some results. And that's the role we play here. So receiving that information is great. Thank you, Dr. Green.
Yeah, thank you very much.
And I'll just say that that group as a whole did a very good job representing their issues and being great advocates for themselves. So, I appreciate that they see that our board played a role, but they were certainly the driver in doing that. So I'm glad to see that happen.
Thank you, Carmen. Thank you very much. Yes.
Any further comments? Well, I'll thank you too, sir, for coming back and letting us know that things apparently are headed in the right direction. And
Well, we
value
we're going to make sure it's still on track.
Okay.
Thank you very much.
Okay. Take care.
Have a good day.
Thank you.
Bye bye.
Are there any further folks desiring to speak in the public session?
Not at this time, Dr. Longley.
Okay, thank you. We'll move on then to agenda item 17, the uncontested calendar. This is the time and place for a public hearing to consider uncontested items 22 through 25. Janelle, has anyone submitted an email requesting to comment on any of the uncontested items?
Not at this time, Dr. Longley.
Adam, are there any late revisions?
No late revisions.
Very good. We'll go ahead and close the hearing. I'll ask for a motion and a second.
I would move the uncontested calendar as presented.
Okay. Carmen has moved. Do I have a second, please?
I'll second.
And Denise has seconded. Call the roll.
Board Member Bradford?
Yes.
Board Member Brewer?
Yes.
Board Member Kadara?
Yes.
Vice Chair Ramirez?
Yes.
Chair Longley?
Yes. The motion carries unanimously. Thank you very much. We'll move on to agenda item 18, the cannabis program update. This time the board will hear an update on the cannabis program. This is an information item only, and no action will be taken, although the board may ask questions and provide direction to staff. After the staff presentation, interested persons will be allowed 3 minutes each to address the board. As a reminder, if you intend to present or comment on any of the items in this hearing or think you might be interested in commenting, you should already be in the Zoom meeting room using the Zoom meeting ID provided on the board's website and the password you received from our staff. If you've not already received a password, you can email us now at agenda5@waterboards.ca.gov. Include speaker comment, those 2 words, in the subject line so we can follow up with you. And Patrick and Adam, I think we need to make, there we go. If we get to it, rather than going through this every time, I need simply to point this out, the directions. And I think that's much more effective. Although for a person that's only on the phone, they need the verbal. Okay. For those of the Zoom meeting, you will be on mute and your camera turned off until it is your turn to speak. Our meeting host, Gene Coughlin from our IT team, will then unmute you and ask you to turn on your camera if you have one. When you're finished speaking and the board members have completed asking questions, you will be placed on mute and your camera turned off. We'll now hear the staff presentation.
Good morning.
Jason, everybody. Yvonne?
Thank you. Good morning, Chair Longley, members of the board. My name is Yvonne West. I am the Director of the Office of Enforcement at the State Water Board, and I'm also here as a representative member of the Cannabis Executive Oversight Committee. And if you can go ahead to the next slide. Now, I'm going to provide you a broad background to the cannabis program, as well as discuss some of the more recent program challenges, including program reduction in staff, which we've recently experienced, as well as an overview of the recommendations contained in our executive committee report recently released or in the process of being released to address the program challenges and staff reductions, and then highlight the next steps for this program. After I'm finished with my broad presentation on statewide issues, I'm going to turn it over to Jason Schroeder. He's your cannabis program manager to discuss Region 5's program more specifically. Next slide, please. So just as a quick background here, as you all know, our cannabis program started as a pilot program centered in Region 1 and Region 5 back in 2014. It became a statewide program in the fiscal year 2017-18 budget and expanded greatly throughout the state. In June of 2020, our Executive Oversight Committee got together for a 2.5-day virtual retreat to discuss ongoing program challenges, address higher level policy issues, as well as developing program priorities and recommendations on identifying efficiencies. Shortly after that meeting, it became very apparent to us that ongoing budget shortfalls in the program we're going to require substantial staff reductions. So the Executive Oversight Committee turned the virtual retreat discussion and focused it on a summary report and recommendations addressing and adjusting for those staff reductions. So if you can go to the next slide. I believe the last time I was here to address you on the cannabis program, we had discussed pretty broad-reaching challenges with the cannabis program and its attempts to help move an illegal industry to a regulated industry and minimize the negative environmental impacts from that industry. More recently, the challenge that has resulted in the funding issues that we're seeing is the low cultivator participation in the regulated industry and in our program. This low participation we can point to a few things that have basically resulted in lower than anticipated enrollment in our program. First of all, a number of local jurisdictions have banned or severely limited the ability for cultivators to become licensed or become legal. And just generally the overarching uncertainties in the regulatory landscape in becoming a licensed cannabis operator or cultivator have discouraged folks from taking that initial step of entering our program, which is one of the first steps in becoming a legalized cultivation, is to obtain our enrollment here at the water boards. Just to be clear, this lower than anticipated participation is not unique to the water boards program. We're seeing it through all the authorizations and licenses that are required, from local to statewide licenses. We're seeing a small percentage of the actual cultivation sites that are out there in these programs or attempting to become legal. This low participation has impacted our fee revenue for our program specifically, as well as the overarching cannabis tax revenue. Both of these are the two sources that fund our water boards program. Another factor feeding into our inability to raise our fees for our cannabis program, generally as a water board program, most of our programs are supported by fees of the folks who are in the program or registered. Unfortunately, again, because we have such a small percentage of registered cultivation sites, and the fact that those licensed sites are subject to additional fees and licensing fees from other state and local agencies, as well as taxes, our ability as an agency to raise our individual fees to support our program is limited. All of these challenges has invited basically the Executive Oversight Committee to determine and how to allocate program resources between permitting and enforcement, and make recommendations along those lines for the board's consideration. So moving on to the next slide. Again, our program funding challenges result from our limited tax allocation. Our fee shortfalls have resulted in a significant reduction, a 50% reduction on our program staff focused on water quality in the cannabis program. Our Division of Water Rights staff has also been required to hold positions vacant over the last fiscal year and going into this year, as well as experiencing a small staff reduction. All of this has required the board to re-examine current practices, develop recommendations to reduce program scope, and identify areas to improve efficiencies. So moving on to the next slide. This is just a chart for your consideration. This shows where the program resources experienced a reduction and where the remaining resources are left. As you see, we're literally cut in half. We have 39 positions remaining in the water quality arena. 39 positions have been eliminated. And then you'll see both Region 1 and Region 5 retain a large number of the cannabis enforcement staff and the water quality left. So you see the program, again, still focusing on the original task force areas. And then just briefly, our office, the Office of Enforcement, retains a significant number of staff as well. The staff in the Office of Enforcement is composed of both legal staff, which support all of the cannabis program staff statewide in bringing forward enforcement cases, as well as a small unit of investigators that are available to address the highest priority enforcement matters throughout the state. And it's anticipated that unit will be called on to address both complaints and high priority enforcement sites in both Region 1 and 5, as well as the regions that no longer have sufficient staff to have their own enforcement efforts. And we can see a number of regions have been reduced to 1 or 2 staff. So moving on to the next slide. Just briefly, before I discuss some of the recommendations of the Executive Oversight Committee report, I did want to just provide a little more information on the Executive Oversight Committee. This was a committee that was formed several years ago out of a recommendation from one of the first program review report that was put together for the cannabis program when it was quite young. This committee is made up of managers and executives from all of the entities that you see here. And all of these members have been active in the development of this current report, and specifically Clint Snyder has been a very active participant, as well as Patrick. Paloopa has been involved in many of our meetings to discuss the recommendations that I'm about to present to you. So going on to the next slide. The Executive Oversight Committee report serves as an outline of recommendations necessary to develop an operational framework that promotes program consistency statewide in the cannabis program. The report outlines definitive steps to reducing our program scope by discontinuing work in some areas while prioritizing efforts in other areas, such as increasing enrollment of potential legal cultivation sites and pursuing enforcement against illegal cultivation sites. The recommendations in the report include objectives that are aimed at achieving the following objectives. They considered policy considerations. There's an intent to bolster program funding, reduce program scope to match available resources, improve communication and coordination throughout the program and with our sister agencies and local partners, gain workflow efficiencies throughout the program, and finally to identify and track metrics for the program. We go ahead on to the next slide, please. In looking at bolstering program funding, the EOC report is recommending a focus on enrollment outreach and education at events where we have a real potential to reach broader audience or to result in a more meaningful response to our program and enrollment in our program. And these types of efforts should be pursued whenever possible. Again, recognizing that we have a reduced program scope and reduced staffing, we really want to focus our enrollment and outreach efforts in areas where we think they will be the most meaningful. And then we recommend pursuing fee schedule adjustments when and wherever feasible in the future, recognizing, however, that they will not be any fee adjustments for this fiscal year. The next slide. The report looks at reducing program scope, specifically on the enforcement front. It emphasizes enforcement of illegal cultivation as a top priority of the program. However, because of reduced resources, we'll have to take a more restricted, targeted priority watershed approach. The priority watershed approach is an approach that we have done since the beginning of the pilot project, focusing on watersheds where we find the most impacts with sensitive habitat as well as impaired water bodies. We are going to have to reduce how many of those watersheds we'll be able to address at any given season because of our reduced staffing. We also want to limit enforcement outside of the targeted priority watersheds to only sites or areas where we have a known concern. And the report identifies a number of elevating factors that would justify going outside of those watersheds. Next slide, please. On the regulatory front, in reducing the program scope, the EOC report recommends deprioritizing enforcement for permitted grows and those folks who are already enrolled in our program. deprioritizing compliance assessment and inspections of enrolled sites, and focusing more on compliance assistance. It recommends limiting enrollment application review. Again, getting folks into the program, emphasizing getting folks into the program and providing assistance and getting them in compliance, but limiting the amount of review we can do for some of those documents. And then it considers processing notices of applicability at the state level, at the state water board, to take some of the workload off of regional board staff and move some of the administrative work into the Division of Water Quality at the state board in Sacramento. And that's an ongoing recommendation that's being developed and refined. Next slide, please. The report looks to improve communication and coordination within the program by continuing the Executive Oversight Committee, recommending participation in partner agency executive level meetings, reducing internal meetings and streamlining communications within the now more limited staff, and establishing 3 program coordinators, 1 at the Division of Water Quality, 1 at the Office of Enforcement as a coordinator for enforcement efforts program-wide, and 1 at the Division of Water Rights to address water rights related issues. Next slide, please. The report spends a significant amount of time in looking at how we can improve program efficiencies in light of our reduced resources. For compliance improvement, the Executive Oversight Committee, there's broad consensus throughout the committee members that the cannabis policy and general order as currently written and structured require a level of staff resources that the program does not currently have. So a strike force will be formed at the Executive Oversight Committee to review the general order and policy in an attempt to identify ways that that order and policy can be streamlined to reduce staff burden associated with implementing the general order and policy. We're also recommend developing additional enrollment compliance assistance tools so the regulated public can get into the program in a more expedited manner and help them comply with the program. There's also a public education and messaging campaign associated with those efforts. And then moving on to workflow improvements, the report recommends reducing backlog, automating, again, the notice of applicability, process issuance and submittal, perhaps at the state board level, and then looking for expedited hearing procedures, as well as exploring whether or not cost recovery can be obtained through cleanup and abatement orders. Moving on, the report also looks at leveraging technology to improve our program efficiencies. So I want to take a few minutes to highlight recent advancements in our technology efforts and what efforts are being further developed and leveraged for the program. So moving on to the next slide. This is the first statewide mapping effort that came out of our cannabis identification and prioritization system. This was a proof of concept in 2014, and then in 2019, we got our first ever statewide map. And this effort identified roughly 30,000 cultivation sites statewide. And you'll see that the majority of those sites are in Region 1 with 20,000 potential cannabis sites identified through this effort. And then Region 5 is the second highest with 7,000. So this mapping was contracted out. We contracted out to obtain this mapping. And now if we move on to the next slide, we're working to bring that capability in-house with our CannaVision program. So CannaVision is an in-house effort that essentially it's an artificial intelligence and machine learning process by which we're training computers to pinpoint objects of interest using the aerial imagery. And we're training them to identify cultivation sites and then other features associated with cultivation sites. In the future, we're going to expand it to find other infrastructure such as greenhouses, reservoirs, ponds, and water tanks. This is just an example of where we used the CannaVision program to identify potential sites. And the good explanation for it is that basically we feed it aerial imagery and it locates cannabis sites, then imports information into mapping software that includes parcel and location. And this is the kind of mapping effort that can then turn around and feed into our SIPS program. So if we go ahead onto the next slide. Again, we talked about SIPS a little bit a few slides back on the statewide mapping effort, but SIPS, which was, as I mentioned, a proof of concept in 2014, we're currently under contract to continue to develop and improve the functionality of this GIS-based platform to better connect a cultivation site's location with potential threats to water quality and supply, so we can again triage our sites, automate our triage of these sites, acknowledging that we don't have the resources to address all of the unlicensed cultivation sites in the state. We are working to refine our capability to triage those sites based on threat to water quality and water supply. So going forward, the hope is we will be able to merge SIPS and Canavision into portions of CWIX and ERIMS, the California Integrated Water Quality System, and the Electronic Water Rights Information Management Systems to improve the functionality and, again, the ability to use this to triage it. We are also at the water boards currently pursuing purchasing statewide high-resolution imagery. In the past, we've relied on free aerial imagery available through NAIPS or Google and other publicly available databases. Now we're moving toward purchasing higher resolution imagery, and this new imagery will significantly enhance the accuracy of both the Canavision efforts and the SIPS platforms. Go on to the next slide, please. So one of the final things that the EOC report will do is it's going to identify metrics to improve accountability in our cannabis program. It's going to identify both regulatory metrics and enforcement metrics. And then the hope is from there we will develop goals for the program. So we'll both track metrics and develop outcomes and goals for the program to achieve going forward to increase accountability and help us refine our efforts and understand where we're being effective and where we may need to divert resources to other areas. So next slide. Our next step for the Executive Oversight Committee is to finalize this report. It's pretty close, but we're going to make some efforts to prioritize the recommendations. Right now, there's a lot of recommendations in there, and we're going to have to prioritize them to which ones need to be implemented immediately, which ones are high priority, low, medium, and low priority. We're going to identify those metrics for measuring success that I just discussed. At that point, we'll present the EOC report and recommendations to program staff. And then program-wide, we're moving forward. We will move forward and identify program goals for each office and region for the 2020-2021 fiscal year and work on developing work plans to implement the recommendations and meet these program goals. So with that, I'm going to turn it over to Jason to discuss Region 5's efforts specifically, but I will be here and available for questions at the end of the presentation. Or now, if you'd prefer.
Are there any questions? Thank you for your presentation. It provided a lot of information that I certainly find useful. Really didn't have any idea quite where you were, so you went through your slides. Thank you very much. So let's go ahead with the next presenter.
Okay, Jason, you can unmute your microphone. I see you there, but we don't hear you. Jason, looks like you're unmuted and video on. I'll stop this share for a second. Jason, we see you, but we don't hear you. You appear to be muted.
Jason, if you'd like to come upstairs, use my office, you're welcome.
Yeah, we're not hearing you, Jason. It appears you are unmuted, but we are not hearing you. Maybe
we can take him probably a minute to get up here.
Okay.
Oh, there you go.
Wait, we heard you.
You hear me?
Yeah.
There you are.
Oh, okay, great. Sorry about that.
No problem. Let's share that presentation.
Okay. So yeah, slide 19.
Let me find where we are.
Oh, hang on just a second here. It just took over my screen, so hang on. Okay. Okay. Let me get back to my slide. Okay. Good morning, Dr. Longley, members of the board. Thank you, Yvonne, for going through the statewide program highlights. My name is Jason Schroeder. I'm a senior engineering geologist in the Reading office. I manage the Cannabis Regulatory and Enforcement Unit in Reading and serve as the region's cannabis program manager. Today, I'll provide an overview of activities and progress made in implementing the board's cannabis program over the past 12 months. Next slide. I'll discuss a brief history of our cannabis program, recent staff reductions and subsequent Reading staff reorganization, progress made in the core activities of the program, which includes permitting and compliance and enforcement, the recent Executive Oversight Committee recommendations and how they'll impact our program regionally, and finally, I'll conclude with a summary of our path forward with the recent changes. Next slide. So in 2014, 11 water board positions were authorized statewide in support of a cannabis task force in coordination with California Department of Fish and Wildlife. 4 of those 11 positions were allocated to the Central Valley region and the Reading office. Staff focused on the 4 core activities identified in the program rollout. Number 1, development of a regulatory program, which involved drafting a regional general order to regulate discharges of waste from cannabis cultivation activities. Number 2, targeted enforcement in high-value watersheds. Number 3, education and outreach to cultivators on the general order and best management practices, or BMPs, at cultivation sites. And number 4, multi-agency coordination at the state and local level. And these core activities have been maintained throughout the history of the program. In October 2015, the Central Valley Water Board adopted the general order for waste discharge requirements associated with medicinal cannabis cultivation activities. The passage of Senate Bill 837 and Proposition 64 in 2016 expanded on provisions of the Medical Cannabis Regulation and Safety Act and created a legal avenue for recreational cannabis cultivation statewide. In addition, the State Water Board began developing a statewide general order. The regional order was rescinded in 2019 and replaced with the statewide general order in summer of 2019. Next slide. So as I mentioned, in 2014, the Central Valley Water Board received 4 staff to kickstart the pilot program. The governor's 2016 and 17 budget provided an additional 13 water quality and 22 divisional water rights positions for the pilot program. The Central Valley region received 2 new positions, which provided a program manager in the Reading office, who also served as the senior over the cannabis unit, and 1 staff in Rancho Cordova. The governor's 2017-18 budget included 9 new positions, which were divided between the Reading and Rancho offices. The increase in positions created the necessity for 2 units in the Reading office, which was split between an enforcement unit and a permitting compliance unit, working under 2 seniors. As of 2019, our cannabis program was fully staffed with 16.5 positions. However, at the end of 2019, due to attrition, there were 5 vacancies in the program. A hiring freeze in early 2020 left these vacancies unfilled until the major staff reduction of July 2020, which reduced program staff to just 8.5 positions. In Reading, all program vacancies were canceled, and 3 staff were reassigned to existing vacancies in other units, including 2 staff and 1 senior. The staff losses in Reading necessitated the merging of the enforcement and permitting compliance units into a single unit as of September 1st, 2020. In Rancho Cordova, these reductions also resulted in 1 vacancy loss and left the remaining vacancy unfunded. Currently, Reading has 6 full-time positions and Rancho has 2.5 positions. Next slide. Some of the biggest challenges for staff are the geographical area that each staff is responsible for and the increase in the number of counties per staff due to staff reduction. Every county within each office's respective territory is assigned to a given staff. So with the recent staff reduction, each staff has doubled the number of counties they're now responsible for as compared to last year. Given that there are no cannabis staff resources out of the Fresno office, just 2 staff are responsible for enforcement and permitting in the southern half of the Central Valley region, while 4 total staff are responsible for the northern half of the region. And just a quick note, the numbers shown in the chart reflect professional staff only. This does not reflect the additional losses of 1 AGPA position and 1 senior position in Reading. Currently, the staffing in the 2 offices seems equitable, primarily due to Lake and Nevada counties being the most active counties, and I'll get a little more into that in a bit. But the program retains flexibility to provide support if and when the workload shifts among the 2 offices. Next slide. So half of program resources are assigned to permitting and compliance. Staff meet this objective through implementation of the statewide general order. This work includes reviewing permit applications, approving enrollment. We're on slide 24. There we go. This work includes reviewing permit applications, approving enrollment, reviewing monitoring reports, conducting site inspections, and completing inspection reports and low-level enforcement up to and including issuance of Water Code 13267 orders. Next slide. There we go. The numbers presented here represent the program goals for general order enrollments and compliance inspections over the past 12 months, which were created, just as a side note, while those goals were created when we were fully staffed. So despite COVID, telework, staff reduction, reorganization, and limited field time, staff have worked hard to try to meet our performance goals since October 2019. We expect that we will actually come very close to meeting or exceeding our enrollment goal by the end of October due to an influx of enrollment applications for Lake County in the past several weeks. As of this morning, checked with staff, we have 50 or so enrollments in process for Lake County and several more coming in from Nevada County.
I'd like to ask a question at this point.
Sure.
What triggered those folks submitting? Was it actions on part of the staff, or was it some other event or whatever that caused those folks to decide to join the program?
I'll talk a little more about that in a bit, but just quickly, it's essentially the county established a deadline because they were getting inundated with use permit applications, and a prerequisite for their use permit application process is that they enroll with our general order. And so they imposed an October 31st deadline, and so everybody's scrambling to meet that deadline so they can get in line for the use permits.
Thank you.
You're welcome. Next slide. So the current landscape for the legal commercial cannabis market is represented in this figure. Represented in green are the counties that allow indoor and outdoor commercial cannabis production: Calaveras, El Dorado, Lake, Nevada, and Yolo counties. These 5 counties are where the majority of staff resources are currently being allocated for enrollment in the general order. Next slide. So enrollments in Calaveras, El Dorado, Lake, Nevada, and Yolo counties account for approximately 75% of all enrollments region-wide and almost 90% of new enrollments over the past 12 months. The remainder of the enrollments in banned counties are predominantly waivers for indoor cultivations within city limits, typically. Since the 2019 program update, 2 counties have passed ordinances allowing commercial cultivation. And Calaveras County passed an ordinance in December 2019, and El Dorado then came online in January of 2020. 4 counties, so Nevada, Lake, El Dorado, and Calaveras, represent the greatest opportunity for enrollment in the general order. Yolo is a permissive county, but they only issue 69 permits, use permits. Lake County currently has this is where I was talking about. Lake County has a deadline at the October 31st for use permit applications. So enrollments are coming in at a rate of about 20 to 30 per week at the moment. And we expect them to drop off a bit in November. Staff is hoping they drop off a bit in November. As a side note, regarding indoor cultivations, at the recommendation of the Executive Oversight Committee, a strike team will be developed to identify potential revisions to the statewide policy and general order. Considerations for indoor grows will be evaluated in that assessment.
So these are permissive counties. The counties that don't allow cultivation could still have grows impacting water quality.
Absolutely.
Do they, are the counties aggressive in addressing that issue, or does that fall strictly to the board?
Actually, yes. And it depends on the county. They all have sort of separate levels of resources, just like we do, and they have different efforts going on depending on where we are and, you know, what level, because some counties don't have that many cannabis cultivation sites as opposed to others. But there are definitely more aggressive code enforcement and cannabis divisions within each county. And I'll get more into that in the enforcement section.
Okay.
And let me just ask this, and this is kind of a guess, but do we have any indication whether some of these counties that currently ban commercial grows are leaning towards permitting? And if so, do they usually reach out to the water board to get things done? I know we're on an election year and there's other topics that probably, you know, take up more air than this one, but do you have any indication of whether we can expect a change on this?
Well, I think that's the hope. My staff, I have advised them to, you know, they do have much more increased workload in terms of how many counties each of them are responsible for. But one of the tasks that I have for them is to communicate on a regular basis with county officials and to keep the finger on the pulse of any county that is potentially going to come on board so that we can offer our assistance in just explaining our process and quote unquote demystify the process for them and even do an outreach event there. Clint or Yvonne might have more input on that.
And it seems like going back to Yvonne's presentation there, I think she said under the SIPS database, there were something like 7,000 grows in Region 5, and we have 826 enrollments. So that's a little more than 10% of the grows. And I assume a lot of those are in counties that don't permit.
That's correct. In fact, according to SIPS, the identification that they have done on sites throughout Central Valley, the highest number of cultivation sites is in Butte County, which is not a permissive county, for example.
Yeah, like the Hanover property that we discussed yesterday.
Correct.
Yeah.
So they have over 1,500 sites that were identified by SIPS.
Okay, well, I guess I was just wondering if, you know, some counties are kind of, you know, on the border, whether or not having this kind of information about the support might help them. But it sounds like you guys are already keeping in touch with counties.
Yeah, if I might, you know, it's a little bit of trial and error, I think, amongst the counties to try to figure out, you know, who has sort of the best business model, so to speak, in terms of providing for permissive cannabis cultivation, potentially with regard to the size of the grow that they allow, the quantity of grows they allow, and the locations of grows that they would allow. The sort of the advantage that we've been able to discover, so to speak, is that if, as Jason was saying, we are alerted that a county is moving toward adopting an ordinance that would allow for cannabis cultivation, then that's really our opportunity to start working with the county at that point in time. Just like was mentioned earlier, if we can get in early and if we can work with the counties, really what we want to try to do is insert the water board's permitting process as a requirement of the local agencies issuing, that license. And if we can do that, then essentially we leverage the local jurisdiction's efforts and essentially better our own. So that is certainly an effort that we're pursuing. Additionally, and as per recommendation of Patrick, as a member of the Executive Oversight Committee, we discussed at length opportunities to increase enrollment and strategies for doing so. One of the recommendations that came out of that report, although it'll be a slightly lower priority, but nonetheless one that we're going to keep our eye on, would be to work with the other agencies, potentially the Department of Finance and the Governor's Office, to develop a marketing strategy so that we can pursue outreach to some of these counties who have bans in place, and potentially work with them to put together a nice business model that would provide for enrollment and thereby increasing our opportunities to protect water quality. So that recommendation is certainly there. Yvonne plays a very active role in higher level agency coordination with the Department of Fish and Wildlife and CDFA, Cal Cannabis, and others. So we're hoping that we can take advantage of that opportunity in the next couple of years.
And you talk about working with the governor's office as we have, from what you've been presenting, we have a lot of information now on grows. And it appears that folks are taking advantage of counties that have weak programs. If you go back and look at legislation that was passed on SGMA, it simply said that if the counties didn't do the job, then the water boards would do the job. And I'd like to consider seeing the cannabis legislation amended to put that sort of language in there. If folks don't step up to the plate and do what they should be doing, they're creating burdens for other counties, and certainly they're creating a burden for the state overall. I think we need to take that into account in legislation. That would be something that I would suggest moving forward on.
Duly noted.
Of course, that's the governor's office that has to make that decision. But.
Yeah, I would suggest that the governor's office has taken that into account, and because it's a land use issue, we do not want to be authorizing land uses in counties. That's just a bit too far. So it's really the land use decisions that the counties have to make with respect to authorizing these activities. So I think it is discussed. There certainly could be a state override for certain provisions, but I know it was radioactive for the state to kind of interfere with that type of local decision making.
Huge land use issues in SGMA, putting farmers out of business if the county.
But in terms of a general plan revision or conditional use permitting, there's with SGMA actually there's no new authority that was provided by SGMA. It was all existing water rights authority. The cannabis permitting does rest on county authority, so I think that's where that's where the distinctions are drawn, and that is that's a pretty big deal.
Okay.
Like it really comes down to politics and maybe financial incentives that could be placed in front of a county like Butte that has 1,300 illegal grows could generate a fairly good revenue stream, I would think, with the permitting process if they were to go that way.
No, I think that's actually fundamentally what the conversation is. And one of the things that I've been advocating for is to go to the counties, be a little bit more proactive and say, look at the county sheriff's office. If you don't collect taxes, you don't have a county sheriff's office. It's the same deal with the cannabis grows. If you don't collect the permitting fees and you don't collect the use permitting fees, you're not going to have an enforcement presence because the board's not going to be collecting its fees either. So that's the trade-off. You know, I think that a lot of the counties within the Central Valley have an ideological opposition to any type of cannabis legalization. You know, and I respect that. I think that to a certain extent, it's denying what is actually happening out there because it is happening. So, you know, and I don't think that genie's going back in the bottle with the way that the system is outside of those counties. So, you know, I think it really is a lot of continued conversations. And again, I think Jason has his staff out there to be a resource. And I also think, you know, just to answer a little bit of Board Member Ramirez's question, really, there's a lot of counties waiting for somebody to do it successfully before they have their own foray into that water. And I think that, you know, you have a county like Calaveras that didn't do it successfully and then retracted its program. You have counties like Nevada County, Yolo County that are moving forward. And I think our commitment is to try and make those counties' programs stand up and work well, so that can provide an example to other counties that might want to have their own programs work well. And so, you know, but it is a deft touch that's required. And I would say it is very different than how SGMA was implemented and how SGMA did not touch any land use authorities, but doing that would. So that's a bridge too far, at least where the legislature and the governor have been for the past 6-7 years.
Your discussion, Patrick, earlier of sheriffs being able to develop a revenue source for activities that they have to carry out anyway strikes me. I think you're right on there, and certainly sheriffs in many counties have quite a bit of influence.
Patrick, I would agree 100% with everything you stated about the ideological issues with marijuana grows. But I also want to point out, I like what you mentioned about the water board reaching out to certain counties and discussing the benefits of having these grows permitted. Where I'm from Kern County here, and absolutely, you know, we're facing a lot of issues with our budget as far as, you know, we depend on oil and ag, and obviously the oil industry is, you know, slowly exiting out of Kern, and this is a county that did not authorize grows, and it's illegal here. And however, but you know, things change with time. A few years ago when that was voted down, I think it's important for our water board to be able to reach out to certain counties, especially the ones where we see the ideological differences, and show them that how this can help with permitting. And sometimes it's just timing. And, you know, when folks are looking for different sources of revenues, it can be a win-win for the water board to make sure that our programs are running efficiently, and also the county. So I hope we have a little bit more dialogue on maybe reaching out to the counties as far as the water board will do that.
Yeah, no, I absolutely agree. I think, you know, in particular, one of the things that, you know, the state is looking at, and I say state, I include the state board, regional boards, is looking into really figuring out the dynamics of the indoor permits as well. Because there have been a proliferation of those. And I think that certain municipalities that are adverse to outdoor grows are a little bit more receptive to kind of turning some warehouse space or turning some indoor areas into grow sites. Those come with their own problems, but I think that the way certain cities have been addressing it is, well, you make sure you've got your water permit, make sure you've got your pre-treatment permit, make sure that you have security, you know, and they tend to set a very high bar on that. And I think the state board's looking at what type of permitting action they expect from that. There's been a lot in like the downtown LA area, other areas where these things have been popping up, and the fee structure doesn't match. You know, the fee structure is very, very low for those indoor growing facilities. And so I think we're looking at, you know, by we, it's everybody, water rights, water quality, regional boards are looking at avenues of kind of making it easier for folks to get permitted. That includes kind of making the requirements for indoor grows a little bit more robust, and really looking at the outdoor permits and the outdoor water rights, and making sure that inside that permit, it's just the need to have, not the nice to have. So if you look at the permitting requirements right now, they're really tough. They're really tough. It's kind of Cadillac plan for maybe not the most urgent water quality issues, or certainly water quality issues that maybe we'll get to eventually. But right now, let's try and stop the bleeding. Let's get a permit that folks can get enrolled in, get comfortable paying permit fees, and get comfortable kind of moving into the sunlight out of the shadows. That's kind of really the big objective. And I think it's I give Clint a lot of credit for forcing these issues forward. I think we recognize them at our board perhaps in a little sharper resolution than the state board did at the onset. And I think right now we're working on kind of melding those two strategies as we move forward with more limited staff.
Yeah, and that's what I was going to say. I recognize that we're asking you for big policy things right after the discussion of how slim staffing is. So I recognize that.
That's right. The resources are certainly very very limited, and you have to be very strategic on how those resources are deployed. We recognize that. So, and so far as the presentation is concerned, we got stopped here with a lot of discussion. Do you want to go on at this point?
Yes. So next slide 28, Gene. Good discussion. Thank you. So there's still opportunity despite some of the doom and gloom of our resources. I'd like to continue to focus on those. So there's a lot of info on this slide, but I wanted you to see the potential for new enrollments for the permissive counties that we actually are working within. So in order to achieve increases of enrollment in the general order, there must be unpermitted cultivation sites in permissive counties where the maximum number of use permits have not yet been issued. So there are two ways to determine potential enrollments, depending on whether or not the county has a maximum number of permits they'll allow. So the first is to either take the maximum allowable permits and subtract the actively permitted sites, or if a county doesn't have a maximum, it's just equal to the number of unpermitted sites that are within that county. So in this chart, the estimated total number of cultivation sites comes from SIPs. We got some recent numbers from Department of Water Quality or Division of Water Quality, aerial imagery from helicopter flyovers or other imagery, and anecdotal evidence from local agencies. They all seem to have an estimate of the number of grows in their given county. So it should be noted that these are potentially moving targets and just estimates. But there is potential for hundreds of new enrollees in the general order, particularly in Lake, Nevada, and to a lesser extent, Calaveras and El Dorado counties. Each county has a unique permitting process with its own challenges. Some examples of those challenges include a lack of a programmatic CEQA process and staffing limitations that restrict the number of use permits they can process in a given month. Lake, for example, can only process 12 use permits a month. Other counties have upper limits to the number of use permits that they'll issue. As mentioned previously, Yolo County is at a maximum capacity for their county use permits. Next slide, please. So one of the methods for encouraging cultivators to come into compliance with the cannabis cultivation general order is through enrollment enforcement. Enrollment enforcement efforts take place in permissive counties and identify sites that meet the requirements of the order that are unpermitted. This entails identifying a priority watershed, identifying cultivation sites within that watershed, sending out notices, explaining the requirements as spelled out in the general order, responding to questions, determining applicability of sites and dischargers, and ultimately enrolling as many discharges as possible into the general order. So this photo shows an aerial view of Nevada County sites taken from a helicopter flyover in June 2020. And this is one method staff uses to identify sites by looking for evidence of cannabis cultivation infrastructure like greenhouses, water tanks, grading, ponds, and cultivation areas. Staff then performs a desktop review of these sites to verify the enrollment status, the proximity to water courses, size of the disturbed area, and slopes to determine water quality concerns. Next slide. The enrollment enforcement letters are typically sent out in batches of approximately 100, at least they have been to date. So 4 of the enrollment enforcement batches that we have done were sent to cultivators in Nevada County, and 1 batch was sent to Lake County. Staff coordinated each of the enrollment efforts with outreach events in the respective counties in an effort to assist cultivators who intended to come into compliance. And just a note on staffing, the enrollment enforcement effort takes about 1/4 of a PY or 1/4 of staff's time during the process of site selection, document preparation, and then follow through of issuing notices of violation, answering questions about applicability, and assisting dischargers with the enrollment process. Next slide. So here's some statistics from the first 5 batches that we've done. Over half of the notices sent were resolved by either enrolling the cultivator or determining that they were not applicable to the program. So we consider this a positive response to the effort. Enrollment in the general order we've found typically averages about 19%. Approximately a third of the identified sites were determined by staff to not be eligible because of either number of plants, it was too small of a cultivation area, or they were no longer cultivating at the site. There were another 7% of recipients who were contacted and determined that they should be enrolled, but they never did. These cases were issued NOVs, and staff are following through with elevated enforcement as time allows. Approximately 4 in 10 of the discharges identified were not able to be contacted for various reasons. So that's a significant percentage of the total, but also not terribly surprising. This is partly indicative of the nature of the cultivator community. The complicated landowner-operator relationships make it very difficult at times to determine who in fact was responsible for an identified site. Outdated imagery and property ownership records can also contribute to return mail or misidentified responsible parties. So moving forward, the use of up-to-date imagery and an improved GIS system, as we expect from the new SIPS platform, will greatly improve enrollment percentages on future efforts. Additionally, in future efforts, staff will work with much smaller batches to ensure that 100% of sites are contacted and accounted for, up to and including enforcement actions beyond notices of violation, such as administrative civil liability complaints. Next slide, please. So I'd like to change gears a bit and discuss the other type of enforcement that we do, not to be confused with enrollment enforcement. So the flip side to our permitting and compliance efforts is the enforcement of water quality violations at unpermitted sites. As Board Member Bradford mentioned yesterday, these are often the folks that are, quote, running just fast enough to get away from the law. I really like that quote. These enforcement efforts occur at unpermitted cultivation sites in both permissive and banned counties, typically requiring interagency coordination with California Department of Fish and Wildlife, State Water Board's Division of Water Rights, and Cal Cannabis, which is Division of California Department of Food and Agriculture, County Code Enforcement, and local sheriff's departments. Next slide, please. Enforcement staff focus on conducting appropriate level of enforcement on cannabis cultivation sites that cause or threaten to cause negative impacts to water quality. Enforcement staff conduct targeted enforcement in response to complaints and referrals from other agencies, including multi-agency focused operations. So this photo shows staff from the Department of Fish and Wildlife and the Division of Water Rights on a site in Lake County in August 2020. Cal Cannabis and Lake County Code Enforcement were also present. Activities include planning, developing affidavits and warrants, site inspections, inspection report preparation, issuance of enforcement orders, tracking compliance with enforcement orders, and participation in enforcement proceedings. Board staff work closely with the Water Board's Office of Enforcement to bring administrative civil liability cases to the board. And enforcement staff routinely coordinate with law enforcement agencies, including local jurisdictions and partner agencies, enforcement groups, to ensure that cases are properly developed, avoid duplicative efforts, and that follow through for site remediation occurs. Occasionally, enforcement staff will also participate in outreach and education events with permitting staff to highlight the importance of abiding by the general order requirements. Enforcement staff also actively participates with law enforcement agencies and groups such as the Environmental Crimes Task Force groups on our ability to assist with coordinated enforcement efforts. Next slide, please. So the Reading office currently has 2 staff remaining who focus on enforcement caseload, and Rancho has 2 staff who split enforcement and perform permitting duties. Despite challenges presented this year, staff still participated in 54 enforcement inspections. This is noteworthy since COVID-19 resulted in decreased inspections during spring and summer of 2020 compared to previous years, and virtually eliminated large-scale California Department of Fish and Wildlife focused operations that occurred in years past. This just speaks to the diligence of staff, and they've really risen to the occasion in the face of the reduction in resources. Next slide, please. So since October 2019, staff have continued to bring progressive enforcement to illegal cultivators, which have resulted in 2 administrative civil liability cases over the past 12 months. One is in final stages of settlement, and the other was heard yesterday at the October 2020 board meeting. We're at the tail end of inspection season, and staff are currently working to complete inspection reports and accompanying enforcement documents. Next slide. Pursuing enforcement actions against cannabis cultivation sites, in particular illegal cannabis cultivation sites, presents numerous challenges to staff. We've talked about some of those today. Often, cultivators are separate entities from landowners. Landowners are not local to the area of cultivation. And these situations can be the result of complex and undocumented business arrangements or lease agreements, and are associated with black market cannabis cultivation. So even the most basic function of determining and contacting a discharger can be difficult and time-consuming. Time to complete administrative enforcement actions, considering the complexities associated with identifying and communicating with responsible parties, can result in delays to final cleanup and prosecution of cases, as we saw yesterday in the Hanover case. Despite these challenges, the program continues to prioritize enforcement activities as a way to encourage compliance with the general order in permissive jurisdictions, ensure proper remediation of sites that are impacting water quality, and to assist with issues associated with black market cultivation. Next slide, please. So given our limited resources, we're continually looking for opportunities to improve the enforcement process. Pursuing an administrative civil liability order often results in years-long enforcement cases with disproportionate fines. Staff is working with management to refine the enforcement process to expedite administrative civil liability orders for both enrollment and water quality violations. This will require development of templates and predetermined schedules of post-inspection 13267 orders, notices of violation, and ACL complaints to be considered by the executive officer. The statewide cannabis program is one of the most integrated water board programs, requiring close interagency coordination to implement the statewide policy and general order. Improving coordination through ongoing enforcement triage and lead agency determination can result in efficiencies in enforcement efforts. We're also looking at ways we can expedite the inspection process through field forms, inspection templates, and electronic devices that will allow shorter production times for inspection reports. Improvements to the Cannabis Identification and Prioritization System, or CIPS, will be completed by May 2021 and will allow staff to more efficiently select and prioritize sites for enforcement by quickly determining proximity to water courses, size of cultivation, and disturbed areas, and identifying slopes. Next slide, please. As Yvonne discussed, the Executive Oversight Committee is finalizing the report and prioritizing recommendations. We expect that their recommendations will result in focusing the program's mission to 2 primary objectives. Number 1, increase enrollment of potential legal cultivation sites. And number 2, pursue enforcement of illegal cultivation sites in restrictive and in legal jurisdictions. So we'll be able to accomplish these objectives by eliminating lower priority tasks, increasing efficiencies where possible, and partnering with other agencies. Next slide, please. So there are many opportunities to increase efficiency in the program. Triaging enforcement inspections will increase our likelihood of spending resources on sites with that have a higher probability of water quality violations. Using improved technology such as SIPs will allow staff to quickly identify a site's current status and potential threat to water quality. Improving our enrollment enforcement process, which means focusing on high-value watersheds, performing enforcement efforts in smaller batches, and doing our best to have 100% follow-up on notifications and notices of violation. Modernizing the general order notice of applicability process will liberate staff to perform core functions in the permitting compliance unit. And improving templates will reduce errors, shorten inspection report prep time, and provide better consistency among offices. And finally, due to limited resources, we'll be relying on our partner agencies to ensure that we're doing the most with what we have. This includes lead agency selection for enforcement activities, coordinating with local law enforcement and code enforcement to get real-time updates on sites of concern, and partnering with the Office of Enforcement's technical team to assist us in our enrollment enforcement efforts. Next slide. I think I missed the next slide. Sorry. Here we go. I heard a great quote the other day about the circumstances we find ourselves in. So, quote, there's no better time to make changes than when our world is standing still. We've clearly had to make a lot of adjustments over the past year, and we still have more to make, but that also means we have opportunities to make positive change in the program. So thank you for...
I want to thank Yvonne and you for presenting an awful lot of very interesting information, I think, which brings us up forward. Certainly brings me forward to understanding the program, where it is, and what your challenges are. I liked your comments towards the end regarding developing templates and streamlining the enforcement process. And certainly that's something that I would very strongly support. I think that it's the way to go. We've done that in other programs with success. So I wish you the best for that. Any comments by board members?
No, I'll just say it was a good presentation, and I know that we asked kind of long questions in the middle, and you guys were able to pick right up, and it was a good, meaningful discussion in the middle of a presentation, so thanks.
Well, sometimes the best time to talk is when a particular point's brought up. It's in context then.
Yeah, I thought it was definitely a good report by Jason and Yvonne, and towards the end there where you made mention, Jason, of the increased enforcement in illegal growing sites, I think is good, because in the southern part of the Central Valley, you know, we have issues here, and with the sources of funding it was limited, and with the counties not wanting to participate in the program, it's been challenging. But to hear that you're looking at increasing enforcement for the illegal growing, I think is a good thing, because we really want everybody to be in compliance. And for those that are not, you know, at least moving forward to address the issues of not the illegal growing, but the problems that it's causing, I think is good. And that you are having your eyes on trying to address those problems is a good thing. Thank you guys for a great presentation.
Thank you.
Thank you.
Yeah, I would echo all that. And I guess it seems like you guys are doing a little less with less, as Patrick likes to say, and it's just so challenging to keep up with it. It seems like it might even be more challenging from a resource allocation basis and staffing if additional counties do come online and the fees aren't streaming in yet, but the program is starting to grow. So I think, you know, you're going to have a bit of a challenge staying on top of that if it evolves that way. I hope it does. But anyway, great presentation and
thank you.
good job.
Yeah, that's the best in the worst case scenario if a bunch of counties come online, right?
Right. Yeah.
But we'll deal with it if it comes. We're trying to figure out how to scale up if that happens, and hopefully we'll be better prepared with these efficiencies built in place to do that.
Right.
Well, thank you very much. Any further comments, questions by board members? Thank you very much, Yvonne and Jason, for a great job.
Thank you.
Moving on, it is now 10:38. We'll take a 7-minute break, please. Be back here at 10:45. When we come back, we will be going on to agenda item 19. How long do you expect 19 to take us?
Hey, Dr.
19 will be a...
Pardon?
Did you mean 19 or 21?
No, 19.
20. Earlier, we were talking about doing 21.
Well, I was moving 21 back before 20. We can move. We can do 21 next. I understand the core's not showing up, so
Yeah, I would support that, Dr. Longley.
we'll do 21 next. Okay, when we come back at the quarter till. Thank you.
Brian. This is Bob. You'll do a sound check.
This is Carmen. I think I have a weird screen. Oh, never mind.
We can't see you, Carmen, or can we see you?
You could. But I have my camera off. See, because
there you go. There you go.
I need one of those lights too.
There's better ones, but yeah, this is what I got.
Is my sound okay?
Yes.
Okay, perfect. Thank you.
So we're back. All our board members here. Is Denise here? Carmen's here. Mark's here. Is Raji here?
Yes, I'm here.
Okay. Oh, there you are. I don't see you until you speak. I'm sorry. Is Denise here? Let Denise get back.
I'm here.
Okay.
Okay.
The other thing we've seen is sometimes folks are present, but it takes a minute to get that unmute button working. Very good. We're ready to come back into session for agenda item 21. This is the time and place for hearing to consider adoption of general orders for waste discharge requirements and Clean Water Act Section 401 water quality certifications for Western Placer County Habitat Conservation Plan / Natural Communities Conservation Plan. This consists of a programmatic general permit, a Placer County Water Agency regional general permit, and a regional general permit. Is there anyone who is contesting the proposed actions and wishes to comment on this matter? Please use the raise hand feature that's been described on the Zoom screen if you've not submitted a comment card and wish to comment.
Hey, Dr. Longley.
Yes.
This is Adam. We've got a number of folks online to comment, so I would say just
we'll go ahead then with the procedure. Since this hearing will be conducted in accordance with the notice of public hearing and the meeting procedures published with the meeting agenda. At this time, evidence should be introduced on whether the proposed action should be taken. The designated party is the U.S. Army Corps of Engineers. The U.S. Army Corps of Engineers has a total of 10 minutes for testimony and a closing statement. All other persons are interested persons and shall limit their comments to 3 minutes, and a timer will be used. All persons expecting to testify, raise your right hand and take the following oath. And this, do you swear the testimony you're about to give is the truth? If so, answer, I do. Please state your name, address, affiliation, and whether you've taken the oath before you testify. As a reminder, if you intend to speak, you should already be in the Zoom meeting room using the meeting ID provided on the board's website and the password you received from our staff. Jean, do you have that general slide to put up, tells people what to do? If you've not received a password and intend to speak, you can email us now at one word, agenda, ANGENDA, and include the letter 5, the number 5. So it's agenda5@waterboards.ca.gov. There you go. And there's the address in the middle. That email address is as you see on the screen. Include speaker comment, the 2 words in the subject line so that we can provide you with a password to access the Zoom site. For those in the Zoom meeting, you will be on mute and your camera turned off until it is your turn to speak. You'll read one. Our meeting host, Gene Coughlin from our IT team, will unmute you and ask you to turn on your camera if you have one when it is your turn to speak. When you finish speaking and the board members have completed asking questions, you'll be placed on mute and your camera turned off. If any designated party is having technical difficulties, please notify us immediately, either by raising your hand virtually on the Zoom screen under the participation tab, or if you're using a phone, by pressing *9. If you can, you may also send us an email with the email address I previously stated, agenda5@waterboards.ca.gov. If there are technical difficulties, we'll stop the hearing to address those issues and will not resume until all designated parties can participate. Does council have any legal issues to discuss at this time?
Yes, Dr. Longley, just two quick items to note. The first one is that we have received two late comments, one from Larissa Berry, president of Defend Granite Bay, and another from Cheryl Burkema. I'm sorry if I'm not pronouncing that right. She's a Placer County resident. Well, the comment period ended in mid-September, and we just got these this week. I still recommend admitting them, namely because there's no prejudice to the board. And if the board chooses to admit, I'd recommend a quick break so I can circulate and the board has a chance to review. So I don't know if you want one other item to note before you maybe decide on that, is some of the interested persons that have been commenting have raised comments on a specific project in Placer County, the Vehicle Inspection Center, sometimes referred to as Carvana. And I just wanted to note this is a pending application before the board. The board will consider this at a later date. Because it's pending, we cannot discuss it today. And so I'd ask the commenters today to refrain from discussing that project. There will be an opportunity in the future to comment on that item.
And I invite you to intervene if discussion on that item begins.
Will do. Thank you.
So before we begin the staff president, I will admit those two letters or emails, as they may be, to the record. And you need some time to send those out to the board before the board goes on, or you believe? I think we can go on to the staff presentation.
Well, I would suggest actually that the board take a couple minutes to review those.
I was going to suggest we do the staff presentation and review them after that, because it's going to take a while for them to get to my computer.
I have them ready to send, but I would recommend a break at some point just so the board members have a chance to review.
Go ahead and send it. If they don't show up, we'll go ahead. Not all of us are on fast systems.
I got the email.
Okay, I have two emails, one from Larissa Berry, I believe, and then another from Cheryl Burkema.
Okay, mine just arrived also.
I received mine as well too, Dr. Longley.
Okay. Take a look at it, and we'll give a few minutes for that.
I have a copy of the Miss Barkima's comments if you need that displayed.
Has any board member not received those yet? Okay, we'll take about 2 more minutes and then we will go ahead and resume we'll take staff comments or staff presentation. Is there any board member that needs more time?
Dr. Longley, I'm barely getting through the first letter. There's a second letter still.
Okay, so we'll give you more time. Let us know when you're ready to go.
Okay, thank you.
Very good. Any questions about the letters that the board members have for staff?
I know that we don't normally accept letters late. I guess I know they've been admitted and I'm not necessarily objecting to that, but these kinds of delays are what we want to avoid. Plus there's information there that I'm trying now to calibrate with what I already know. So I guess I'm just saying that it's important that we get these letters in advance. And certainly if it's something that just came up, we weren't able to get, I understand. But generally, this is the reason that we need things early.
Well, maybe I erred in admitting them, but they have been admitted to the record. Folks have read them. I think you make a very good point. I think we have to be discriminatory on what we admit late. With that, let's begin with the staff presentation.
Carrie, I have a copy of that. Would you like me to run it?
This is a different presentation. On 21.
Oh, sorry, 21. Stephanie.
Oh.
Let me pull that up.
I do have a copy also. I can try to share my screen if you'd like.
If you'd like, sure.
Sure. Let me pull it up. Give me just one moment.
If you have any trouble, I can do it too.
Will do. Thank you. Okay, let me pull up the show. Here we go.
We see it.
Okay. Good morning, Chair Longley and members of the board. My name is Stephanie Tadlock. I am the Senior Environmental Scientist supervising the 401 Water Quality Certification and Dredging Unit in the Sacramento office, and I have taken the oath. The next item for your consideration are 3 tentative general orders for waste discharge requirements and Clean Water Act, Section 401 Water Quality Certifications for the Placer County Conservation Plan. During this presentation, I will describe the elements of the Placer County Conservation Plan, including the benefits the plan provides for Placer County mitigation resource availability, describe the United States Army Corps of Engineers permitting strategy, as well as the permitting approach the 401 program will implement in collaboration with state and federal agencies and the Placer Conservation Authority partners. I will outline the permit strategy proposed by the Army Corps of Engineers and how we are able to assist in creating a streamlined permitting process through our regional board permitting. I will also discuss communications that have taken place with local citizens regarding the 3 permit authorizations and their concerns in the Placer County area. Finally, I will conclude with the regional board staff recommendation for the 3 tentative general orders before you today. The nearly 270,000 acre plan is a regional approach to address issues related to planned development and species habitat conservation following a comprehensive conservation strategy over a 50-year period. It also accomplishes a streamlined permitting process for applicants that will protect and preserve water quality and resources. The plan will establish a 47,300 acre interconnected preserve system and connect to an additional 15,957 acres of existing reserve present in the plan area. The proposed preserve system will protect county's remaining vernal pool habitat and provide protections for 14 plant and wildlife species, including 9 that are found on state and federal threatened or endangered species lists. The unique composition of Placer County includes foothill and valley land cover types. The program will allow for more effective conservation of habitat, open space, and agricultural areas while supporting future growth and development needs within the region. It provides a balance between habitat protection and permitting at the local level, while allowing for conservation initiatives between landowners and stakeholders within the agricultural regions of the plan area. The program is built around a no net loss of wetland value and function. The PCCP includes extensive restoration of aquatic resources, including compensatory mitigation, but also restoration above and beyond typical mitigation requirement ratios. Commitments to conservation include requirements to restore 3,000 acres of vernal pool complex, 30 acres of vernal pools, 20 acres of fresh emergent marsh, and 30 acres of riverine and riparian complex areas within Placer County. The PCCP plan area is located within Placer County and includes Placer County and the city of Lincoln, as shown in Plan Area A in the off-white and tan color on the map. Other activities for consideration may also be located in the cities of Auburn, Loomis, Rockland, and Roseville, though they are considered non-participating agencies and are shown in the light gray areas. Within western Placer County, the plan area is bounded on the north by Nevada and Yuba counties, on the east by the city of Auburn and California Highway 49, on the south by Sacramento County, and on the west by Sutter County. Within Sutter County, the plan includes 1,724 acres along the Raccoon Creek floodplain, as well as an additional 33 miles along Auburn Ravine, Raccoon Creek, Cross Canal, and the East Side Canal. Under the program, property owners or project sponsors required to mitigate species and habitat impacts will either dedicate land to a newly established preserve system, shown as a reserve acquisition area in dark green, or also preserve or enhance existing habitat, shown in light green, as the existed protected area or other reserves. The plan area includes 50 to 60,000 acres within an available acquisition area that would become part of the contiguous reserve system. The reserve system will contain oak woodland areas, aquatic and wetland habitat ecosystems, valley foothill riparian habitat, and vernal pool grassland areas, all of which provide critical habitat coverage for 31 covered species, including vernal pool tadpole shrimp, valley elderberry longhorn beetle, Central Valley Chinook salmon, Central Valley steelhead, California red-legged frog, northwestern pond turtle, and Swainson's hawk. The area allows for consideration of potential future growth areas in Placer County and provide adequate protections and mitigation for impacts as a result of future growth in valley and foothill areas. The program also includes the opportunity to mitigate by paying fees into an in lieu fee program to support property acquisitions for future compensatory mitigation project development. The Placer County Conservation Program will be managed by the Placer Conservation Authority, or PCA, formed collaboratively between Placer County, the City of Lincoln, Placer County Water Agency, and the South Placer Regional Transit Authority. The goal of the PCA is to address future necessary growth that is anticipated in Placer County and new development areas that will be subject to sensitive species, wetlands, and water quality regulation at the state, local, and federal levels. While the PCCP will be managed by the Placer Conservation Authority, the Regional Water Board will retain regulatory oversight on all notices of intent submitted for coverage under the portions of the PCCP that are permitted, including those submitted under Section 401 of the Clean Water Act. The purpose of the PCCP as a whole is to improve species and aquatic protection on a regional scale, integrate Endangered Species Act and Clean Water Act Sections 404 and 401 permitting, streamline the federal and state permitting process while maintaining protections for species habitats and water quality impacts, and provide mitigation certainty for all impacts subject to local, state, and federal regulation. The PCCP is broken up into 3 distinct plans and programs: the Habitat Conservation Plan and Natural Communities Conservation Plan, the Western Placer County Aquatic Resources Program, and the Western Placer County In Lieu Fee Program. The Western Placer County Habitat Conservation Plan and Natural Community Conservation Plan will protect fish and wildlife and their habitats and fulfill the requirements of the Federal Endangered Species Act and the California Natural Community and Conservation Planning Acts. These 2 permits outline requirements for protecting species that are listed on the threatened or endangered species list at both the state and federal levels. The PCCP also includes the Western Placer County Aquatic Resource Program, or CARP. The plan fulfills the requirements of the Federal Clean Water Act and other applicable state laws and regulations. The CARP applies to all aquatic resources considered waters of the state and upland riparian habitat within the riparian zone, supported by stream hydrology and considered a sensitive habitat in Placer County. CARP is designed to protect streams, wetlands, and other water resources. The CARP also applies to the region's greater stream system, which includes waters of the United States and state, and upland areas outside of the ordinary high water mark. CARP requirements were developed through a collaborative effort between the United States Army Corps of Engineers, the United States EPA, the U.S. Fish and Wildlife Service, NOAA Fisheries, and the Regional Water Quality Control Board, the California Department of Fish and Wildlife, and Placer County. The In Lieu Fee program was established to manage future mitigation projects in Placer County. The program establishes guidelines, responsibilities, and standards for the establishment, use, operation, and maintenance of the program through a bank-enabling instrument. The goal of the program is to protect aquatic resources that are designated as waters of the United States and state through mitigation projects that compensate for unavoidable impacts to waters of the United States and state that result from activities authorized under Sections 404 and 401 of the Clean Water Act and the Porter Cologne Water Quality Control Act. Fees paid into the program will be used to create resource protection projects throughout the preserve system within the plan area. In April 2020, the Army Corps of Engineers requested certification under Section 401 for activities covered under a streamlined permitting strategy for the PCCP. The Army Corps of Engineers proposed a 5-approach permitting strategy for the PCCP similar to a previous strategy considered by this board in April and August of 2019 for the South Sacramento Habitat Conservation Plan in Sacramento County. The strategy's 5 approaches include issuing a programmatic general permit to authorize projects that have low impacts to waters of the state, a regional general permit issued for Placer County Water Agency infrastructure projects within the plan area, in lieu fee program projects, a procedure for authorizing permits under a letter of permission, and a process for authorizing an abbreviated standard permit. The 3 individual tentative orders for Placer County presented to you today cover authorizations for 3 of the 5 approaches of the Army Corps strategy. These are the programmatic general permit that cover projects that fall under a set impact limit established in the Aquatic Resources Program, a regional general permit to authorize Placer County Water Agency infrastructure projects that qualify for coverage under the PCCP, and another regional general permit for mitigation projects funded by the Western Placer County In Lieu Fee program. Large-scale projects that submit an application for a letter of permission or abbreviated standard permit with the Army Corps of Engineers will be evaluated on an individual basis and receive their own separate 401 certification. These will not be authorized under the 3 identified general orders presented today. The first tentative general order for consideration is the General Order for Waste Discharge Requirements and Clean Water Act, Section 401, Water Quality Certification, Programmatic General Permit. Projects authorized under the PGP are for specific covered projects held to specific low threshold impact limits. Covered activities authorized under the PGP include projects that will not result in more than 3 acres of permanent impacts to wetland habitat, 500 linear feet of stream channel habitat, and 1,000 linear feet of irrigation ditch impact. Development and infrastructure projects that qualify are similar in nature and would result in minimal individual and cumulative impacts on water quality. The Regional General Permit issued for Placer County Water Agency projects will cover infrastructure projects that will not exceed a total of 1/4 of an acre of wetland impacts, 300 linear feet of jurisdictional stream channel, and up to 1,000 linear feet of irrigation or water supply canals or drainage ditches, provided the ditch or canal is not a relocated or channelized stream. Bank stabilization activities are limited to no more than 500 linear feet along the bank of a jurisdictional stream, no more than 1,000 feet of irrigation or water supply canals or drainage ditches, provided again that the ditch or canal is not a relocated or channelized stream. The permit also does not allow for more than 200 linear feet of sediment to be removed to restore the channel to previous conditions. The purpose of the Placer County In Lieu Fee Program Regional General Permit is to authorize the implementation of the PCCP In Lieu Fee projects approved by the Interagency Review Team to provide compensatory mitigation for activities authorized under the program area. The Interagency Review Team is comprised of the United States Army Corps of Engineers, United States EPA, California Central Valley Water Board, U.S. Fish and Wildlife Service, NOAA Fisheries, and the California Department of Fish and Wildlife. These projects will be developed within the PCCP's interconnected preserve system and will provide compensatory mitigation in lieu fee credits for activities authorized under the PCCP. An individual project covered under the Placer County ILF Regional General Permit and authorized under this order may not result in a reduction of aquatic resource function and services. Regional Board management and staff did not receive direct public or stakeholder comments during the initial 21-day public comment period on the application when the application was received from April 24th through May 15th of 2020, nor during the 30-day comment period for the 3 tentative orders from August 14th through September 13th, 2020. However, toward the end of the latter comment period, a concerned individual reached out to State Water Board with questions regarding the State Board's involvement with the PCCP and regulatory oversight of wetlands covered by the program. Central Valley Water Board staff contacted the individual and received additional concern about specific development projects. State Water Board and Regional Water Board staff have communicated with the concerned individual to clarify the jurisdictional authorities between both agencies and clarify that specific projects at issue would not be eligible under coverage. The orders before the board today will be considered, the orders before the board today are the ones under consideration, and future development projects will be on a future board agenda. Further, the tentative orders before the board ensure California Central Valley Water Board's continued regulatory oversight over covered projects and their potential impacts to waters of the state, including wetlands. The orders do not delegate our regulatory permitting authority to other agencies involved in processing permits for the PCCP. Staff recommends adoption of the 3 separate orders before you today: the Placer County Conservation Program Programmatic General Permit, the Placer County Water Agency Regional General Permit, and the Placer County In Lieu Fee Program Regional General Permit. This concludes my presentation. Thank you for allowing me to provide you with the details and recommendations for this regional conservation project in Placer County. I am more than happy to answer any questions you may have at this time.
Well, thank you, Stephanie. Are there any questions or comments by board members for Stephanie?
Thank you for the presentation. That was very concise and informative. I guess I guess the premise of this, the need for this permit, you stated is future necessary growth, and I always kind of question how necessary growth really is. Anticipated and planned growth is probably unavoidable, but that said, it seems like I was a little concerned about the public participation issue, having looked at the letter from the concerned citizen, but I think you addressed that satisfactorily. And the only other question I guess I had, I noticed a number of small projects could be approved under the general permit. Does the permit address cumulative impacts from numerous small projects that might be enacted over the next 20 years?
It does. We look at them at an individual basis, and each individual project that that submits a notice of intent, we make sure that their mitigation is appropriate within the ratios established by the Corps. So cumulatively, they would still have a mitigation or lower impact threshold than what would ordinarily happen outside of the PCCP.
Okay. Thank you.
Mm-hmm.
So this is Carmen. So on Member Bradford's question, is it possible that 2, let's say, identical projects, one is in early, has certain requirements to comply, and someone who's like the 100th project, right after 99 have gone in before them, same project, different requirements because of a cumulative impact?
It would be the same requirements at this time. We wouldn't treat later projects with less requirements than we would with the original projects. We also have
more requirements.
I'm sorry.
For more requirements.
Yes. As at the time, we have to also consider the resources that are available in the county at that time, and as the program moves along, the permits that we're requesting today only extend over a 5-year period. And we treat them as, after 5 years, we take a look at the inventory, we take a look at our requirements as the water board, and we take a look at any mitigation ratio changes that we have. And we collaborate with all of the other agencies and Placer County to determine what would be best each time we look at renewing these permits. So what the requirements are now could be much less stringent than they are later on down the road when you're looking at a depletion of potential resources and potential impacts to any habitats that happen to be available at that time.
This is
okay, and that's good. Thank you.
I just wanted to clarify a little bit. These 3 orders establish a versus elsewhere in the Central Valley, except for in the Sacramento area where we have a habitat conservation plans like this. This actually establishes a way for the local entity to establish and allow for mitigation in the best possible way that they've devised and collaborated with other resource agencies. So while what this actually does is it actually helps to minimize those cumulative effects of the growth that's going to occur, versus in other areas where we don't have something like this. Mitigation might be done far away from where the projects are. There isn't an organized plan to protect the most sensitive species, things like that. So I just wanted to kind of clarify that's really what this is trying to do, this plan.
So on slide 15, I believe there was limitations placed on the size of projects that could proceed under the permit. And it's my assumption from what I'm hearing that it's conceived that there will not be cumulative effects if projects are maintained at that level, that any project over that size has to go through an individual evaluation and receive its own permission to proceed. Is that correct?
That is correct.
Right. Okay. Any further comments by board members?
No, I'm glad to hear about the 5-year review process. I think that helps my concern quite a bit and cumulative effects.
Okay.
Yeah, Dr. Longley, I just wanted to comment that I thought the approach that is being used is a good one, laid out to help with the mitigation, but also gives an avenue for the citizens, a process for which they can follow through on to make sure that things are in place and working together. So I thought it was a good presentation, and thank you for the information provided today.
Thank you.
Thank you.
And I'll echo the comments of our fellow board members. You guys did a wonderful job in the presentation. And I think this really lays out a wonderful plan. Thank you all.
Okay. Any further comments by board members? Hearing none, we'll now proceed with testimony by the U.S. Army Corps of Engineers. Is there a representative present from the Corps? I had seen earlier that a representative may not show up. Is that correct?
That's correct. I don't believe one is.
Okay. We'll go ahead then. We'll now hear from any person interested who is not a party to this proceeding, but who wishes to comment. Janelle, how many folks do we have wishing to comment?
Hi, Dr. Longley. We have quite a few on the list, but there's only one that says he wants to speak, Michael Garabedian, and the remainder of them would like to raise their hand if they desire to speak.
Okay, so we'll proceed with Mr. Garabedian. While Mr. Garabedian is speaking, if anybody else wishes to speak, please raise your hand on the screen so that we know that you want to talk, and we'll proceed then on to you. Mr. Garabedian, please.
Thank you, Chairman Longley. Mike Garabedian, Placer County tomorrow. I live in Lincoln and I am sworn in. I want to thank you for this opportunity. I think I may need 4 or 5 minutes, but I'm going to zip through this even faster than I'd planned in the first place. Just calling attention to the Clean Water Act that for public participation shall be provided, encouraged, and assisted. And of course, under Section 401, that is 1341, the state is authorized by the law to do the public involvement planning and so forth. And of course, the senior staff council's responsibility includes directing staff in design of public participation in processes. And that's all important because one of the infrastructure projects is the 15-mile New Placer County Parkway Freeway. There are vernal pools everywhere out there, and that's one of the biggest sprawl-inducing projects. So there are two issues where we'd like to have meetings with the board before this proceedings. One on in-lieu fees to nail that down and get specific, and also on urban runoff problems. As you probably heard of, there's the urban runoff mortality syndrome in Puget Sound for the salmon up there, and that has shown to have some application, though not fully investigated, to endangered steelhead here. And we could discuss that, but I think the most productive way might be in a meeting. We have a lot of problems with the governance. I've had experience with the coastal plan and the Adirondack Park plan, New Jersey Pinelands plan, and the Desert Renewable Energy Conservation plan. And the governance that was proposed for this is just a city and county, two and one from the other, and was after the comment period ended. That's when that happened. So that is pretty iffy to understanding. So there's an agreement, a 45-page agreement, doesn't have a public sector in it. Usually these kind of things should have some kind of involvement other than the local, or they're just commenting at the Conservation Authority meeting. Everything up to this time, it has relied on the stakeholder group that was around for quite a few years. The interagency review team and so forth. And the attorney on there for developers, Mr. DeLuca, who I've known off and on for years before, as he said, he read every page of that over and over every time and commented, and you can see it in the language where there's a lot of language that will make it very iffy on implementation and very unclear. So our main request to you, and I think I can wrap up in about a minute, is we'd like to see public workshops on the issues of this, where the wide public in the area is involved. You know, there's a 322 square mile development area that the public is largely unaware of, hasn't been covered in the newspaper. So,
Mr. Garabedian,
yes.
Time's up, but go ahead and finish up.
Okay, so this is my conclusion. The HCP. This is one of the first HCP NCCPs to have this kind of major wetland vernal pool action in it, and it's a precedent. We would look forward to. We would like to work with the regional board on this, and we think it takes more work at this level because the stakeholder group is not the public. The other groups, all the federal and state agencies, were not the public. And we're trying to get them and their boards to now listen to the public on what the final thing is, which wasn't revealed till August with the 3,000 pages of document, though there were the final EIR. So really, that's our concern. This is too major a project, too much major wetlands issues long-term, too vague a government authority structure to let go, and we hope you take some time to involve the public, involve us in the couple meetings we're talking about, and an opportunity to sit down on this. But thank you for this opportunity very much. Very critical to be able to address you this morning. Appreciate it.
Thank you, Mr. Garabedian, for your comments. Board members, do you have any questions or comments?
I have a question. What is the practical effect or the prejudice of not going forward today and allowing for more time?
Well, that's actually, Mr. Garabedian, before you answer that, what Vice Chair...
Sorry, that was a question for staff, Dr. Longley.
Okay. Okay. Well, I have a question, Mr. Garabedian, before we go with that. Mr. Garabedian, were you asking that we not go ahead or that we set up these meetings on in lieu fees and urban runoff after we adopt?
The only way I've thought of that it might work is to do that before you adopt. If you didn't do it, we would certainly continue to want to meet with you because in implementation, it's going to be a long implementation and you will have further opportunities. But we would hope for at this time before you act.
Okay, thank you for that clarification. Carmen has requested the staff to give input on this.
So, Carmen, can I just ask you, were you asking the prejudice of not moving forward today against the projects, or are you asking, are there projects looking to move forward, or can you give me a little bit more?
I guess I was asking for the benefit of, does moving forward today close the door on the issues that are raised by the speaker? But I think that Mr. Garabedian explained that preference is that, that nothing go forward today and that they have time to input. But I understand that moving forward today doesn't close the door permanently. And I guess that's the clarification that I wanted sort of made in public.
I guess if I can say something, we feel the public involvement, I don't know if you can hear me, is so critical that if the board doesn't do it, the public is going to have to do it and invite you to our meetings. But it's really essential, I think. I don't hear, there are other speakers on the line, perhaps they could address the issue of prejudice. It's been pending for 19 years or so. It's hard to see how a few more months could affect anything. Hard for me. Thank you.
So if either Adam or Patrick could address that, I'd appreciate it.
I can just say one thing. I think what needs to be clarified here is what action we're taking.
Yeah.
Go ahead, Patrick, if you want to jump in there, but that would be the one thing.
No, I think it's some of the issues that Mr. Garabedian is raising are pertinent to the actions that would be approved under these programs. So, again, I think getting into the individual details of the program, of the individual projects, is something that there is a process for continuing to engage on this. This is rather the process, though, so that by which the water board's mitigation components are going to be addressed. So I didn't note any particular objection to what we're adopting here today. It seems to be more as to the individual project by project approval that would happen under this.
Well, if I may say, that's the problem. The implementation under it without public input. Public input needs to be had in this, and the public needs to understand what is going to happen with this and what the impacts are. And the two issues, for instance, the lack of attention in an EIR or otherwise to the salmon, the urban runoff that by the vast area of we're up to 300 potential square miles that wipes out the microorganisms and the invertebrate species, upsets the whole food chain, is something that can be mitigated to some extent. We know with the filtering through soils and grasslands and things like that. But this is a major change that could affect endangered steelhead and other species in the waterways. And that's why I think it's so critical that the Port of Cologne Act authorities be brought to bear on this, which haven't been part of the discussion from our point of view.
That's actually, again, I think so you are aware that the Placer County certified the final EIR, correct? We're a responsible agency, and the Port of Cologne Authority is mentioned in the EIR.
Right. And that's basically up to this point, everybody's turned towards the old stakeholder group, and I don't see anybody on that as expert in Porter Cologne, which my exposure to it was last amended, the act, in 1969, and in my law school water law class, Hap Dunning, we studied those changes. And from my point of view, there's so many, it's probably in time for another review, but absent that, is the critical need to give attention. A number of the points mentioned, I disagree with how it's interpreted, and I would hate to see us have to wait for a local process that goes through the zoning administrator and then the planning commission, both of them with $600 fees at the county, to finally get something that gets to the board, or that we would have to guess. It's the public involvement doesn't say, if the public has concern about what's being done, can they take it to you? I guess we could go to a board comment period. It's the weakest thing, that public involvement about how it will operate under the plan is just not described, except there's a place where it talks about, in the agreement, the public could speak to the conservation authority. That's just, usually plans have something where the public can engage and not have to pay big fees to get through the local process.
And I think that answered, oh, sorry. Yeah, I think that you guys have.
Anyway, we would like to work with the board on this. Excuse me. I think it would be a great opportunity because it's such a precedent.
Thank you. Thank you, Mr. Garabedian, and thank you, Adam.
Well, certainly the board would like to work with you too, Mr. Garabedian, and this issue you point, these are two important issues, in lieu fees and urban runoff. Something we can consider further when we deliberate on this. We can go on to the next speaker unless another board member has a comment at this time. Hearing none, we'll go with Chris Beal, please.
Thank you very much.
Thank you, sir.
Mr. Bill, you can unmute your microphone.
Thank you. Can you see me now?
We can, yes.
Very well, sir.
Hi, my name's Chris Beal. I'm with Resources Law Group, and I'm here for Placer County. I live in Sacramento, and I have taken the oath. I just wanted to address a couple of points that have come up. The first is public involvement. I think, as someone has mentioned, the county and local partners have been developing this plan for nearly 20 years. And while when we embarked on this journey, we had hoped that it wouldn't take quite so long. One of the advantages to having a long-term planning process like that is there have been ample opportunities for public input. There have been dozens of meetings of the Placer County Board of Supervisors open to the public, where public comment was allowed. And that's all leading up to the formal NEPA and CEQA process, draft documents available for review, public workshops, and several meetings since with opportunities for public comment. So I just want to make sure folks understand that this has been a plan that includes many opportunities for public comment. And during implementation, there'll be a public advisory committee to advise the Placer Conservation Authority, which will be responsible for implementing the plan over time. So that's the first point. The second point, there were some questions raised about cumulative effects, and I just want to highlight the fact that one of the advantages of a regional long-term plan like this is that it is able to address cumulative effects in, I think, a way that it's difficult to address in any other way. So a plan like this, the Placer County Conservation Plan has a 50-year strategy for protecting aquatic resources within the planning area. And that includes both a long-term strategy for permanently protecting aquatic resources in a reserve system and restoring those resources, restoring vernal pools and wetlands over time. But also from a larger perspective, because the plan is married to the land use planning agency's land use planning efforts, there are long-term incentives for developing in areas where the impacts are likely to be least impactful from an environmental perspective, and directing resources to preserving the most valuable resources. And that's something that's very difficult to accomplish on a project basis. And that strategy has been analyzed in the environmental impact report and environmental impact statement that's prepared for the plan. So it does provide a cumulative impacts analysis for this 50-year planning horizon. So I think the concerns obviously about long-term growth and cumulative impacts are well-founded, but we really believe that this plan addresses those kinds of impacts in ways that can't really be addressed under the usual project-by-project permitting. So thank you for the opportunity to comment.
Thank you very much, sir. Any questions or comments by the board members? We'll go then to comments by Cheryl Berkema. I hope I pronounced that correctly.
You can unmute your microphone.
Good morning, board. Thank you very much for considering my late comments. I am a proponent of a placer conservation program. I think there are a lot of good aspects to it. As Mr. Garabedian mentioned, the implementation and cumulative effects are very concerning. I put in my late comments, thank you for accepting them. In parallel, there has been a project as an example of some of our concerns as citizens. The Carvana project, before the piece...
I'm sorry, I'm going to have to stop you there. That's a pending application, so we're not able to discuss that project during this board meeting, but there will be opportunity in the future to comment on that item. Thank you.
So my concern is not on the project itself. My concern is on the process which took place, which was for an applicant to, I'll just use an unknown name, an applicant to provide for a permit from the State Water Agency. The State Water Agency returns a response that says a project level EIR is required.
I'm sorry, that's still about the same project. If you could constrain your comments just to the orders that are before the board.
Okay.
Thank you.
So I think that one of my concerns is that, first of all, when we talked about cumulative impacts, I will use an analogy. Roseville has the distinction of being the fifth worst in the United States for air quality. I plead with this board to ensure that that does not happen with water. This has been directly due to the long-term government management of this area. The reason for the PCCP being selected in the area that it was selected was for that anticipated growth. The anticipated growth, in the statement of overriding considerations for the Sunset Area Plan Placer Ranch, which is directly in this area, it was because of the opportunity for jobs based upon a university, a Cal State University, at Placer Satellite expansion. The previous chancellor, he just left office, stated that there would not be a university. So I would suggest the Center for Biological Diversity has filed a lawsuit. The EIR is at challenge for the statement of overriding considerations because there was also a state-led survey and the university was not even included in there. So the statement of overriding considerations is at challenge. Similarly, a sister project with SACOG is also under lawsuit by the California Clean Energy Commission. And they state that there is no agency that is going to take on the evaluation of these huge projects with multiple agencies. So we look to the individual agencies because of the way they're presented with the Placer Conservation Authority. There's a similar one for SACOG. And so those authorities have so many agencies. Unless you're Mark Zuckerberg, you're not going to be able to defend against these. So we look to these individual agencies to help us with this process. That we don't feel like we can do that. In addition, some of the projects locally, we have a planning commissioner in Placer County that has been fined severely by California Fish and Wildlife.
Just Kama, you're considerably over your 3-minute limitation. Could you finish up in about 30 seconds, please?
Okay, thank you. So I think the implementation is definitely a concern. The cumulative impacts, we have projects such as the Winery and Brewery Ordinance, which have water impacts, and those were only evaluated on a small percentage, but then established across the entire county. Our concern here is that finding legal loopholes, having the best lawyers doesn't mean that it's the best plan. Having appropriate mitigation and monitoring would certainly be helpful, and we look to you to help us from the prospect of water. Thank you very much for considering that.
And thank you for your comments. Any questions or comments by board members? Thank you very much. I believe we have I believe Chris Beal is waiting to testify. Am I correct?
I believe he spoke already.
Pardon? Oh, yes. Am I missing somebody who's wishing
Greg McKenzie.
Okay, let's go with Greg McKenzie.
You can unmute your microphone.
Okay, hopefully you can hear me now.
We can, yes.
Good afternoon, or still good morning, Mr. Chairman, members of the board. Greg McKenzie, Placer County Conservation Program Administrator, 3091 County Center Drive, Auburn, and I have taken the oath. So I'd like to thank staff for their thorough presentation today. Ms. Tadlock did an excellent job of explaining the overall plan and program, and it covered the Habitat Conservation Plan, Natural Communities Conservation Plan, and perhaps most importantly, in this instance, the County Aquatic Resources Program and the relationship to the Corps' programmatic permits and how the 401 certifications will work. It is my understanding that a similar process is currently working and effective for our neighbors to the South Sacramento Habitat Conservation Program. Staff has worked cooperatively with us and provided comments on our County Aquatic Resources Program throughout its development. I won't delve too much further into the items that Chris Beal, acting as County Counsel, provided to you, but I will note, just to provide some context, that we do have support from various watershed groups, including Friends of Auburn Ravine, Dry Creek Conservancy, Placer Land Trust, Wildlife Heritage Foundation, Sierra Foothill Audubon Society for the PCP, which necessarily involves the Corps' programmatic permits as well as the 401 certifications. The county has obviously a 20-year commitment and multiple millions of dollars invested in this program. It is time to start implementation of this program. The longer we wait, the more projects proceed without a regional comprehensive conservation strategy in place to provide effective, more comprehensive, more landscape level mitigation. So as you may have gathered from staff's comments, currently project mitigation may go outside of the county. Under the conservation program and our County Aquatic Resources Program, mitigation for project effects would be required to be mitigated for in Placer County. And it does include extensive, because of the NCCP Act, conservation measures above and beyond mitigation that Ms. Tadlock covered so eloquently. So I also note that the county's commitment to this program, we already are approximately 5,000 acres into lands under either conservation easement, fee title acquisition, or an irrevocable offer of dedication on the Bear River, Markham Ravine, Doty Ravine, Yankee Slough, and Raccoon Creek. So with that, if you have any questions for me, I'd be happy to answer them. Thank you.
Thank you very much, sir. Are there any questions for Mr. McKenzie? It sounds to me as you're anxious to get a permit and begin to implement that permit. There has, Mr. Garabine was talking about a number of issues he considers important, such as in lieu fees and urban runoff, and was talking about the need for public participation. Could you address your public participation plan for items such as that?
Chair Longley, was that for staff?
That was for Mr. McKenzie.
Okay.
Yeah, I'm happy to address that. Chris Beal touched on that briefly, but let me give you a little background to as the premise. 20 years of public participation over the development of the conservation program. Fast forward to 2018, when we started intensive public outreach in advance of adoption hearings, 15 public meetings and workshops. Fast forward again to 2019, release of all the draft documents, including EIR, EIS, 5 additional meetings and public workshops. Fast forward again to the final EIR, EIS documents, 5 noticed public hearings, workshops, including your meeting here today, all of which Mr. Garabedian has provided public comment to. And so, as Chris mentioned, our public outreach, it doesn't end here. It really has another beginning here. We do have a 12-member Citizens Advisory Committee that's required to be formed as part of the Placer Conservation Authority's work. This program does not obviate the need for additional public meetings and outreach. Each project that comes forward, discretionary project that comes forward to the planning department at the city or the county, requires necessarily public notice and outreach. And so ultimately those do go through additional public hearings, workshops, and mitigation measures and conditions on covered activities, which all get applied, will all be publicly available. So with that, I hope that answers your question.
Thank you very much. And before you leave, any questions or comments from board members for Mr. McKenzie? Thank you very much, sir, and appreciate your indulgence in explaining my question. Thank you.
Thank you, sir.
Very good. Do we have any more individuals wishing to testify?
If so, I would suggest they've raised their hands to signal that they had.
I haven't seen any come up here.
I haven't either.
Good.
Currently no hands raised.
So we'll go ahead then. I assume that a representative from the U.S. Army Corps has not shown up.
No, sir.
Since none is here, we'll now hear a closing statement by staff.
Yeah, briefly, if I could have Stephanie address some of the process behind a notice of intent, which is kind of an integral. I know Greg may have addressed some of the bigger components about how the county will continue to engage the public, but we have a narrower slice of the overall project, but there is an additional component. I think Stephanie can describe that just a little bit.
Thank you.
I can, thank you. The part of the process in listening, I took a few notes with Mr. Garabedian's comments regarding public participation prior to and further beyond the approval of the tentative orders today. The process that we have in place under the 401 certification is going to mirror what we have in place for the Habitat Conservation Plan in Sacramento County. And what will happen involved or embedded in one of the attachments, we have what's called a notice of intent, and that would be their intent for the project. When that application form is filled out, it is sent directly to us. We do take a comprehensive review on the project, ensure that it will adhere to the guidelines within whichever permit they happen to be applying to. make sure it adheres to the PCCP guidelines, the Aquatic Resources Program, and if there's anything that would potentially cause it to fall out of that, it would receive an individual certification, full 30-day public review. But these projects, because we're having these tentative orders today, doesn't mean that we don't involve the public in any of these future projects that are coming in. We do have a mechanism to inform of projects that are coming in for coverage under any of these potential tentative orders. And as I said, anything that could potentially come forward that doesn't that could be questionable or might not fall within the guidelines, we'll make sure that we have out on public review. And if it's contested, then obviously we'll bring it before the board and make sure that you're privy to that information. After the notice of intent is reviewed, we issue a notice of applicability that makes sure that each of these projects adheres to the specific guidelines and conditions that are within those general orders. And again, we do further, and Greg had mentioned it as well, we do prefer to involve public comment as well as local, regional, and federal, other state agencies within our permitting process. So we do make sure we have a very comprehensive review before we approve any of our projects.
And when groups have concerns, I presume they can contact you directly.
Yes, that's correct. They can contact myself or any of my staff or any of the management, and we're more than happy to consult, set up meetings, and discuss any concerns that they may have and what we may do to help alleviate those concerns.
They can write the board, in which case it gets distributed to board members and so forth.
Yes, absolutely.
Very good. Any questions, comments by board members?
I mean, it looks like a great project and it looks like a good framework. I heard and understand some of the risks or concerns or fears expressed by the speakers, but I think that those are all addressable within the program as proposed. So I am grateful for their point of view, but I think that those things are protected with the framework as it's presented today.
Yeah, and I concur with what you say, because what I'm expecting is that there is going to have to be a dialogue with the public, not just the committee, but with the public at large as this program is rolled out. Excuse me. And I would expect to hear that doesn't happen. Any further comments?
No, I would agree with all that. And I think the gentleman from Placer County made a good point as well, that projects will continue to be approved piecemeal if we don't get this in place, which could result in more cumulative impacts, obviously. So, I think they addressed the public comment issue adequately, and I'm ready to move on.
Very good. Any further comments from board members? We'll then, I'm asking for an executive officer recommendation.
I recommend adoption of the proposed orders.
Thank you very much. At this point, then, I'll close the hearing, and discussion will be confined to the board members and the advisory committee. Your thoughts? And I'll ask for, if you're so inclined, I'll ask for a motion and a second for that motion.
And by your thoughts, thoughts of the other board members.
That's right.
Yeah, Dr. Longley, this is Denise. I would just like to comment that I think it's been a process that has included public participation throughout. I think to move forward with the project is the right thing to do. The process that staff has gone through has continued to show opportunities for public participation, and the continuation of that is still there. So there is opportunities. I think the program that's been presented today is a good one. The role that our staff is playing is viable. The agency's participation. So throughout this period of 19 plus years that it's been going forth, I think it's ready to go to the next level, and public input is involved in that process as well. So I'll entertain a motion if there are no other comments from staff, from our board members.
You said you'll entertain a motion. Does that
Yes.
mean you're making a motion?
I will make the motion.
Thank you very much. And I'll entertain further comment.
I would agree with Board Member Kadara's comments. I think this is a wonderful plan. I think there's been ample time for public participation, and I think we need to move forward. So I would be seconding that motion.
Thank you. Is there any further board member comment? Hearing none, call the roll, please.
Board Member Bradford,
Yes.
Board Member Brar,
Yes.
Board Member Kadara,
Yes.
Vice Chair Ramirez,
Yes.
Chair Longley.
Yes. The motion carries unanimously. I'd simply like to state to those that are online and are participating in this meeting today that this is something the board takes great interest in. Certainly we expect your further involvement, and we expect you to have opportunity for that involvement, and particularly if you feel that you're not having that opportunity, I would certainly like to hear of that. These are important items that have been mentioned that need to be developed, these among others, as time goes forward. But that I believe is part of the implementation and how you implement that. So very good. Thank you for your time and interest in this issue. I think at this time the board is ready to move to the next item. But before we do that, it's 12 o'clock. It's item number 19 on our list. I think it is. Yes, the forestry activities update. How long is that?
That'll be about an hour, Dr. Longley, with board questions.
Okay, we have an alternative, and I'll ask board members for input on this. Mark has to leave around 1 o'clock. We could proceed now and take a break after that, or we could take our break now. What are your druthers? That's a new word, by the way.
This is Carmen. I'm flexible either way. I'm happy to go forward because I had a sandwich at the break, but I don't know how everybody else is.
Well, and Dr. Longley, I don't want to hold things up here. I'd be very happy to get a copy of the presentation and then follow up with staff afterwards if that makes sense, and let people take their break now.
Yeah, I happen to think that
that's fine.
Extremely important. But yeah, okay. Appreciate that, Mark. With that said, we will 45 minutes work for staff and board members.
Yes.
45-minute break. Some people, I'm concerned, may have to make lunch for children, but okay. We'll be back here 1:45.
Thank you. And I'll follow up with Angela after I receive the presentation.
Thank you very much.
Thank you, guys.
Thank you.